My children need me doesn't really pull at my heartstrings. All right. Are you all ready to proceed?
We have decided to change our plea to true.
All right. Court is calling 2020 CR 9869B, State of Texas versus Christine Hernandez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Lorraine Efron?
Are you Christine Hernandez?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Somewhat.
All right. What do you not understand?
I'm sorry, what was the question?
Have you reviewed the motions
Oh,
to
yes,
revoke
yes, I'm
with your
sorry, yes.
attorney? Do you understand them?
Yes, I did. These are.
Are you the same Christine Hernandez who was placed on deferred adjudication in 2020 CR 9869B? For the offense of prohibited substance in a correction facility, drug, phone, or alcohol on November 10th, 2020 for a period of 2 years. Is that you?
Yes, ma'am.
State?
Violated condition number 2, on or about the 5th day of April 2021 in Bexar County, Texas. The defendant, Christine Hernandez, did then and there illegally use marijuana in violation of condition number 2.
How do you plead to that? True or not true?
True.
And Your Honor, we waive and abandon the other violations.
All right. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand that?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there an agreement?
There's not an agreement, Judge.
All right. Would you, I don't have a trial court certification on her.
Oh, no, I'm sorry. I didn't do that.
That's okay. Oh, I'll put it on there.
Okay.
Thank you. All right. We are back on the record. State, what are you requesting?
Your Honor, we're requesting that the court follow probation's recommendation, which is to adjudicate the defendant guilty and send her to SATA for between 120 and 180 days, followed by aftercare.
All right. And what are you requesting?
But we're requesting to be continued on deferred and be ordered into intensive outpatient treatment, which he's very motivated for. I mean, one thing I discussed with her was also some kind of mental health support.
Mhm.
I think she agrees and does
Yes.
feel that she needs that, and it appears to me that she would benefit greatly. She's never been evaluated. I'm not sure she has an actual diagnosis of any mental health disorder, but it does appear that some kind of mental health support is warranted here. Her sister and daughter are here. Both her daughters, in support of her. She does have family support. Her daughters do rely on her quite a bit. She currently resides with her mother and helps her mother there and helps her daughters. And so one thing that is causing her a great deal of anxiety standing before you today, of course, she knows this probation has been a mess. Yeah. But that her family does rely on her quite a bit. And I think she would, if the court would allow, just like to say a few words to the court about what she's requesting.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
My name is Christine Hernandez.
Yes. What did you wish to say?
Okay, I know that me being on probation and it was a second chance for me and I did mess that up completely. I wasn't thinking of anybody but myself, and I wasn't thinking of my kids. And I just ask you that you don't have sympathy on me, but on my kids, because
No, I don't do that here.
I'm sorry, but it's just that I haven't seen my kids and I saw them right now. But I haven't, I'm human. And I did make a mistake, and it was just like I was scared, and I did another mistake and another mistake and another mistake. And I don't want to make an excuse and say that I was not my fault. It was my fault.
All right. Let me just tell you right
I know
now.
better.
So at the end of the day, I'm not giving you outpatient treatment. So that's off the table.
Okay.
Either you're doing inpatient treatment or either you're going to prison. So which would you prefer?
I mean, whatever's best for me, I guess.
No, I don't know what's best for you. That's you know yourself. You know if you have a drug problem. Obviously you do because we're here. You are not doing outpatient treatment at all because you can't write your own program. If you could have written your own program, you would not be here. You would have successfully completed this probation.
I know.
So no, you know yourself better than I do, better than your attorney, and better than the state. So you're either going to inpatient treatment or either you're going to prison. And at the prison, I will sentence you to 3 years and you can be in the therapeutic community. And once you completed your term, you're done. But if I send you to inpatient treatment, if you are unsuccessful on this probation, you're looking up to 10 years in the prison. So which would you prefer?
Well, inpatient.
All right, I'll deny the motion. Alternate amend conditions. She doesn't need a new tap, does she?
Judge, her case, and her case expired November 9th of 2022.
Ah.
She will need a new tap.
All right, so your case has expired. So what I'm gonna do, violation number 2 is true. Gonna find you guilty. Alternate amend conditions. To sentence you to 8 years in the prison, suspended for 6 years. There's to be a TAP evaluation while in custody. Follow all TAP recommendations. If TAP recommends outpatient treatment, then we'll start with ISF, cognitive and substantive. And you said you're helping your children. How are you helping your children?
I'm everything to my children.
Now, what does that mean?
Well, I'm the mom. Their dad's never been in their life and I do everything for my children. I send them to school. I pay for everything that they do. I pay all the bills. I
How
help
old are
my-
your children?
My children are 20, 16 and 9.
All right. So who is the 9-year-old with?
The 9-year-old right now is with my mother.
All right. And the other child, who is she with?
They're all right now staying at home. They're with my mother.
They're with your mother.
Yeah.
Who is?
And I think they're actually present here today.
Yeah.
Okay. All right. Well, you need drug treatment. Otherwise, you shouldn't be in their life. Do you have any grandchildren?
No, I don't have any.
Okay. So TAP evaluation while in custody. Is there anything else she needs?
I don't. Anything,
Your Honor,
but not prison.
after the ISF, since you have been adjudicated, which like any of the other conditions.
All previous conditions are to remain. And you're going to have to do parenting classes. I don't even know if you completed that yet.
I did. I have the certificate and stuff at home.
All right. And then after she's released, we'll do the UA hotline. Is there anything else she needs? Is there anything else you need from the court?
Um,
All right. So she's going to remain in custody until that's done. Ms. Hernandez,
yes.
and we're off the record. Here's the thing. You cannot come to court and use the fact that your children need you to try to get sympathy from me and have me do something other than what I would do if you did not have children. What you should do is take care of your children in the free world and do what it's expected of you, and you wouldn't be here.
I know.
And it is a shame that you had to have your children come down here because Deputy Laura will tell you, your attorney will tell you, and Deputy Mejia will tell you, bringing in your children to say, my children need me, doesn't really pull at my heartstrings because I look at facts to see what's going on. You understand? All right, good luck to you.
And I think her sister would also say that she would be in support of some kind of mental health, that there is a mental health component here.
All
And so
right.
we were just gonna, I don't know if there's
What-
anything further. I think probably what the court has ordered is going to be sufficient. to
All right.
cover
Um,
those needs.
But Sean, can you also do a mental health, a MIC evaluation?
Yes,
All right, so you need to let them know if there's any mental health issues. You understand? All right,
I think that would be good and help her be successful, actually, hopefully,
okay,
get in the right programs.
all right, thank you.
Okay, thank you, Judge.
Adam Sancho. Oh, they're gonna enter a plea? All right, thank you. Court is calling 2021 CR 2982B, State of Texas versus Annette Zavala. Could I have parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
James Milan for the defendant.
Are you Ms. Zavala?
Yes.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and Supplemental Motion to Enter Adjudication of Guilt. I'm sorry, that's something else. All right, did you review this document with your attorney? Did you understand it?
Yes.
Are you the same Annette Zavala who was placed on deferred adjudication in 2021 CR 2982B for the offense of attempted possession of a controlled substance, penalty group 1 less than 1 gram, on May 26, 2021 for a period of 2 years? Is that you?
Yes.
All right, state.
Violated condition number 23 on or about the 19th day of April 2023 in Bexar County, Texas. The defendant, Annette Zavala, did then and there failed to submit to drug testing as directed by the supervision officer in violation of condition number 23.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objection?
No objection, Your Honor. In fact, she actually did complete her community service hours and all
Okay.
that stuff.
All right, did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 23? You need to speak up.
Yes, ma'am.
Is there an agreement?
Yes, Your Honor. It's to extend the probation term to 2 years and amend the residential treatment with SATIV followed by aftercare.
And Judge, we're in agreement with that. The only issue we would ask the court is if she could turn herself into SATA or begin the wait for a bed in a couple of weeks. This is our first setting, but she does want to take the SATA, but she has childcare issues with her granddaughter. She helps her daughter take care of her granddaughter. She's got to tie up some loose ends at home. And so all we're asking, Judge, is if she can turn herself in a couple of weeks so that she can tie up those loose ends at home. She said that she'd be clean today if you wanted to test her.
Oh, yeah, let's do a UA today. All right, do you need any water?
No.
All right, we're going to do a UA. All right, we're back on the record in 2021 CR 2982B, State of Texas versus Annette Zavala. What are the drug results?
Your Honor, there were, the results were positive for methamphetamines and amphetamines. Ms. Zavala provided a list of her prescription drugs, and there was one prescription when we looked at the drug list for these particular drugs that she was positive for. It was not listed on that drug list. We did do a little Google search to see what we can find out. It says that it can come up false positive, but it does not indicate what it can come up false positive for.
Okay,
Your Honor, she swears she did not use any illegal drugs. It looks as though hydroxyzine tamoate will make false positives. We have a list of the medications that she's taking, and that's the one that we believe may have created a false positive.
okay. No, I understand. I was just trying to figure out mentally where she is, but my decision wasn't going to be based on whether or not she was positive or negative. It was just whether or not what you all were requesting would be appropriate or not. So my decision on revoke or not revoke was not going to be based upon that. All right. Is there anything else from either party?
No, Your Honor.
All right. The court found violation of condition number 23 true. The court is going to find you guilty. The court is going to revoke. The court will sentence you to 30 days in the Bexar County Jail Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Do you understand? All right. They're going to take you into custody. The clerk will see if you actually have the amount of time you have available. Who's here on Roland Esquivel? All right, court is calling 2015 CR 1977, State of Texas versus Roland Esquivel Jr. Can I have parties announced for the record for the state?
Hank Wilkins from the state.
Mick Aguilar on behalf of Roland Esquivel.
Are you Mr. Esquivel Jr.? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First amended motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? Are you the same Roland Esquivel Jr. who was placed on deferred adjudication in 2015 CR 1977 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams on July 20th, 2015 for a period of 5 years and extended for 2 years? Is that you? All right, state.
Judge, I'm on the first amended, violated condition number 1, on or about the 26th day of December 2020 in Bexar County, Texas. The defendant, Roland Esquivel Jr., committed the offense of resist arrest, search, transportation in violation of condition number 1.
How do you plead to that? True or not true?
Sure. Violated condition number 1, on or about the 26th day of December in Bexar County, Texas. The defendant, Roland Esquivel Jr., committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. And Your Honor, we waive and abandon the other violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find 1 and 1 true. Is there an agreement?
Subject to your approval, Judge, the recommending a 5-year sentence in TDC and taking TIC, both those case numbers have just been approved.
Yeah, yes, Your Honor, that's right. TIC cause number 652-828 and 652-829.
And what's to happen with the drug case that's within the motion?
I think that's already been closed, Judge.
Okay. All right, Mr. Esquivel, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes.
Court will follow your agreement. The court is finding violations 1 and 1 true. Court is going to revoke.
But as you do that, it was not part of the agreement, but we had asked the prosecutors, or we told the prosecutors we were going to ask for time to get his affairs in order.
Oh, just 1 second. So the court is going to grant the motion, find you guilty, sentence you to 5 years in prison, taking into consideration 65282, 65289, give you credit for any time served. And counsel, what are you requesting?
Judge, we were hoping to get time to get our affairs in order. He does have a wife and 2 children that are here that he needs to make sure that he are taken care of while he's doing his time.
Oh.
He's not on GPS. He does understand that once he's pled true and he does not show up, you do not have to follow the recommendation of 5 years PDC. The full length of punishment would be all the time.
All right, that will be denied. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Esquivel, I understand that your attorney wanted you to get your affairs in order, but all you had to do was report on probation, not commit any new offenses, and you did both. You understand? All right, good luck to you. I'm doing great. Court is calling 2023 CR 3227B, State of Texas versus Cal David Hardy. Can I have parties announced for the record for the state?
Danny West, for the state of Texas.
Defense?
Bob Hicks representing Kyle Hardy.
Are you Mr. Hardy?
Yes, I am, ma'am.
All right, you entered a plea to theft under $2,500 enhanced on May 30th.
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 16 months in the state jail facility. There's no application for deferred adjudication. The state is opposing your application for community supervision. Have both parties had a chance to review the PSI report, state?
Yes, Judge.
Defense?
I have, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
None from the defense, Your Honor.
Any witnesses, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, the court will hear argument.
Your Honor, at least here in this case, there were several cases that were currently pending against Mr. Hardy. State is taking into consideration several of those cases. It's in light of that we are asking for the 16 months in the state jail facility due to the fact that this wasn't his first or his only offense. He also does have a prior criminal history. He has several cases from Bexar County and even out of county. Additionally, at a prior theft under $2,500 enhanced from 2020, he was eventually, through much difficulty, sentenced to 186 days credit in the state jail facility. So again, based off prior history, we'd ask that it be 16 months.
All right, defense, what are you requesting?
Sorry, Mr. Hardy requests that the state consider placing him on community supervision. As it says very clearly in the PSI and in the TAP evaluation, he has had a cocaine habit for the past 7 years or so. As a matter of fact, when he was taking coke, when he started using cocaine, he quit using the other. He was at the time using methamphetamine and quit using meth because of his cocaine use. It had also got him to quit smoking marijuana. I don't think I've ever seen anybody rehab themselves using cocaine, but he admits that he has a drug habit. He admits that he has a problem. And I would request the state consider giving him probation, because if we send him to the state jail for the next 16 months, in 16 months, we're going to have somebody back with a drug problem. If the court would allow him to follow the recommendation on the TAP, which was the substance abuse track at the intensive at the ISF, state ISF, followed by ASP to make sure that the treatments that he received there are working. I believe he has a child who has no PASO. He has family who live outside of Bexar County. And he had been unemployed for quite some time at the time of this offense. He was high at the time of this offense. And I believe that part of sentencing in the court is for the purpose of punishment, but I believe it's also for rehabilitation. And I believe it's much more constantly congruent with the hope of rehabilitating Mr. Hardy, that you put him on probation rather than sending him to the state jail. So
All right, Mr. Hardy, are you able to see the screen with your criminal history?
I wear glasses, but I see this one.
All right, so in 2016, you were sentenced to 32 days jail for possession of controlled substance penalty group 3, less than 28 grams.
Yes, ma'am.
July 2016, you were sentenced to 28 days for criminal trespass private property. August 23rd, 2016, criminal trespass to private property, you were sentenced to 20 days. October 11th, 2016, theft $100 to $750, you were sentenced to 90 days in the jail.
Yes, ma'am.
February 2017, criminal trespass, private property, 36 days jail. March 16, 2017, criminal trespass to private property, 10 days jail. August 3rd, 2017, criminal trespass to property, 26 days jail. September 2017, criminal trespass to private property, 22 days jail. October 30th, 2017, criminal trespass to private property, 26 days jail. January 1st, 2018, evading arrest or detention, 30 days jail. June 2018, criminal trespass to property, you were placed on deferred adjudication, that was revoked and you were given 60 days. July 11, 2018, public lewdness, 60 days jail. August 22nd, 2018, criminal trespass to a building, vehicle, 42 days jail. January 30th, 2019, criminal trespass to private property, 30 days jail. May 2020, indecent exposure, 41 days jail. August 2020, criminal trespass to private property, you were given, let me see, that case ended up being dismissed for another. August 11th, 2020, criminal trespass to property, dismissed over. May 23rd, 2021, indecent exposure, 80 days. September 2021, criminal trespass to private property, that was dismissed. Indecent exposure, dismissed. And I'm assuming these indecent exposures are, he's homeless and maybe he's urinating in public. And then you have a possession less than a gram in 2018, dismissed insufficient evidence. September 2019, theft of a person, 90 days state jail. January 2020, theft enhanced $2,500, 6 months in the state jail facility. June 2022, evading arrest detention, 4 months state jail. January 19, 2023, here we are. And then you have this out of state things. June 2011, possession of marijuana, 5 days jail. January 12th, 2012, stealing, 8 days jail. And that's from Missouri. Then you go to California. And then Kansas.
Yes, ma'am.
All right. So I tell that to you, Mr. Hardy. You're not a good candidate for probation, right? You're just going to have to do better with your life. And I will ask that you be placed in the therapeutic community at the state jail facility. If you want it, you're going to have to request it, but they will help you with any drug issues you have. And then once you're released, you can go to drug places here in San Antonio. They are free. So if you want help, you can get it. But if you don't want it, what's going to end up happening at some point in time, you're going to be a habitual. And if you continue on this vein, you're going to end up spending the rest of your life in somebody's jail, be it California, Lavaca, Oklahoma, Texas, wherever it may be. You understand? So I'm going to deny your application, find you guilty, sentence you to 18 months in the state jail facility, give you credit for any time served. This will run concurrent with cause number 708-955. Take in consideration 2023 CR 3616, JN number 2109814, grand jury number 790756, and I'll request the therapeutic community. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Do you understand?
Yes, ma'am.
All right. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to your attorney. Do you understand? All right. We can go off the record. You say you have a child?
Yes, ma'am. Richard, just turned 1, man.
All right. So here's the thing. You need to do better, and you need to be an example for your child. If you don't plan on doing better, not using drugs, not committing crimes, then don't be in that child's life, because you're going to be a hindrance. You understand? All right. Good luck to you. Court is calling 2022 CR 1725, State of Texas versus John A. Dominguez. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Charles Bunt for Mr. Dominguez.
Are you Mr. Dominguez?
Yes, ma'am.
You entered a plea of no contest on May 22nd, 2023 to the offense of indecency with the child by contact. According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years. There are no applications, and this is to run concurrent with the case out of Lavaca County. There's to be Chapter 62 compliance, no contact with the complainants. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report, state?
No objections.
Defense?
No, Judge.
All right. State, do you have any witnesses?
State has no witnesses, Your Honor.
Defense, any witnesses?
No, Judge, just argument.
All
After you
right.
Have a chance to read the letters.
And just give me 3 minutes to read the letters submitted by counsel.
Thank you, Judge.
One is from Alyssa Molina. The next letter is from Yolanda Dozat, Deauzat. The next letter is from Eric Rodriguez that the court is reading. All right, the court will hear argument. State,
Your Honor, state would like to point out, and the court has reviewed the PSI and the stipulations in this case.
Yes.
The state will just cover some of the more high points of that. Sexual abuse started when the complainant was 7 years old. She said she was forced to touch the defendant at that age. It continued and got worse as the defendant would touch the complainant's breast and pubic region. The complainant specifically recalls the defendant penetrated her at least 3 times with the penis. That the complainant, Skyland Dominguez, suffered trauma and had to go to Clarity for mental health treatment. And there are serious concerns about whether she would even be able to testify if this case had gone to trial. And that's part of why we came to this agreement that we did, given the allegations. And so the state would ask that you meet the cap at 10 years. The allegations are very significant, and what happened and what the defendant stipulated to is very significant. And I will point out that while the complainant Skyland had to go to Clarity for this treatment because of what the defendant did to her, she said that the defendant abused her while she was at Clarity.
well, somebody needs to talk to Clarity then.
And Your Honor, the state is asking you to meet the cap at 10 years and sentence the defendant to 10 years in TDC.
All right, so just a second, are you saying that the complainant was at Clarity, which is a facility, and you're saying that somebody from Clarity allowed him to go into the facility? Is there proof of that?
That is understanding, yes.
Is there proof of that?
That's what the complainant has said in the report.
All right, because the court's understanding is that anybody who goes to Clarity, if you're going to visit someone, even if you're a parent, you have to sign in. So is there any thing of that nature? Is somebody planning on suing Clarity because they let somebody in who's charged with this offense to see?
The state is not aware of anything like that.
Okay. Counsel?
Sorry, Judge.
Oh, yes, you may proceed.
Oh, on behalf of Mr. Dominguez, Judge, we know that the court has read the PSI. We are understanding of the severity of the offense. However, my client, through his plea of no contest, was hoping not to have to put anybody through anything further. He has the support of his family, his mother, his wife, his son. They're all present back here in the back. He's asking the court to sentence him to 7 years.
All right, Mr. Dominguez, anything you wish to say to the court about this offense and why you did what you did?
He'd rather not talk, Judge.
All right, you'd rather not say anything. All right. And state, you're telling me the complainant has, I'm assuming, mental health issues and some other issues.
There are issues, yes, sir.
All right, the court is going to find you guilty, sentence you to 10 years in the prison. This run concurrent with Lavaca County Cause number 2018-09100990 CR. Chapter 62 compliance. There's to be no contact with the complainants. And the court will give you credit for any time served.
Judge, I'll be giving the clerk some dates from when he was in jail in Lavaca County that I believe will be entitled to as well.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? You need to speak up.
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When this happens, guess what? Someone's childhood is ruined. They will never be a child again because of what you did. When you go to the prison, you need to sit there and think about it. You understand? All right.
Good morning, Your Honor. Sid Greehey filling in for Tracy Franklin. I'm here for defendant Robert Shanahan.
All right. And where is Tracy Franklin?
She is in Frio County right now, Your Honor.
Do you know about this discovery?
I know that there's discussion about a pretrial diversion program.
No, we're here today for discovery. Was there a pretrial diversion on this case?
No, Judge, we've tendered an offer.
Yeah, an offer has been tendered. There's no pretrial discovery on this case. So do you know about the discovery in this case and what is missing?
I don't believe that anything is missing, Your Honor. She's
No?
in trial.
She is doing what?
I believe that she's in trial right now. So we're just asking for a pretrial reset on this case, Your Honor.
No, the question is, do you believe she's in trial or you know she's in trial?
I know that her and Cole Nettles were in trial in Bear County. I know that she has cases in Frio. I'm not sure if she went to Frio today or if she's staying for the trial with Cole Nettles today in Bear County.
Well, here's the thing. If she's not in trial, she needs to be here. Today is not a pretrial diversion for Mr. Shanahan. Today is discovery day. And this is set for a discovery compliance. And if you're filling in for her and you don't know what discovery is missing, then this is all for naught. So I would suggest that you find out, one, if she's in jury trial, because if she's not, then she needs to appear on this Zoom screen or either in person. And two, if you talk to her and discover she's in trial, it does no good to fill in for her if the defense doesn't know if discovery has been received or not. So I'm going to put you, Mr. Shanahan, back in the waiting room, and this attorney is going to figure that out.
Thank you, Your Honor. I apologize.
Oh, no problem.
Real quick.
Right. Probation told me they had spoken with your attorney, and probation spoke with me. And my understanding is they've had a chance to speak with the prosecutor. And so there may have been some miscommunication. So my understanding is that the state is going to request that the motion be withdrawn. Is that correct?
Yes, Judge.
So on this case, I understand there was some miscommunication, but you're going to be given new conditions. You need to sign those. So there will not be any miscommunication after today. You understand? So from here on out, everything you do, you need to ask yourself two questions. You know what those questions are? First question. Any action you take, you need to ask yourself, because this potentially result in me going to the state jail facility for 2 years. If the answer is yes, you don't do it. Next question. Is this something that maybe will result in me going to the state jail facility for 2 years? If the answer to that question is yes or maybe, don't do it. You understand? If you have any questions about anything or if there's some confusion, you can always come back to court. If you have an issue, let probation know. If you feel that probation is not addressing it, then you can come in and address it with me. You understand? Do you have any questions about anything? All right, good luck to you. And they told me your UA was good.
Yeah.
Okay.
That's when my daughter was born, so I made a little bit of changes. I wanted to keep my family. I have to make changes with myself before I do anything else. So
That's good. I appreciate that. You know, I always tell parents, If you have no intention of being a parent that your child would be proud to say, this is my dad, this is my mom, then don't cause chaos in their life. Just let them be on their own. Send your child support, but just let them live their life. You understand? So I'm glad that you've made changes,
Take care of 3 kids, so it ain't easy, but
but it's joyful.
yeah.
And how old are the 3 children?
One was just this 15 of this month. Should turn 3 next month. He's about to be 2 on the 23rd, and I got my recent one of 4 months.
Oh, that's awesome. When you have little bitty babies that size, it's
No sleep.
always great because but it's no sleep, but it's no sleep for good reasons. You never want the sleep to be because you told your child to be in at 9 and now it's 9:05 and they're not there yet. So it's a good thing. All right. Good luck to you. Okay.
Thank you.
You're welcome.
Excuse your honor. after you
Yes,
sign-
after you sign the conditions and make sure there are no miscommunications. All right.
Yes, your honor.
Hello, Ms. Gomez. All right. So my understanding there, I wouldn't say complications, but some things that need to be done in your case. I've been made aware that you're Native American. Is that correct?
Yes, ma'am.
Right. So your attorney is going to make some phone calls to, I don't even like the word reservation. What's another term other than reservation?
I think that is the term.
I don't like the term, but okay. He's going to make a call to your tribe to see what type of programs they have available for you. And then make contact with personnel in Eagle Pass to see about that. All right. And we're going to reset you for 30 days. But if I have the information before then, your attorney will be able to put this back on the docket sooner.
I think you told us a week, Judge.
Yes. No, I'm just going to set it for 30 days. But if everything is prepared in a week, all you have to do is call the coordinator and we'll put it on the docket for a week.
Okay.
All right. And if you all have no answer at that time, we'll still put it on the docket within that week. If something happens where nobody's giving you the answer that you want to receive, or if something happens where they say the answer is no, then you can still bring it back in the week.
Okay.
But this is the 30-day reset is in case you call the reservation or call the people in Eagle Pass and they say, yes, we can do it, but it's going to take us another week or so.
Okay.
All right. So Ms. Ferguson, can you give me a reset on this on 30 days with the notation that the defense counsel can come in at any time to put it on the docket? All right. So we'll do August 24th. And counsel, if there's any issues and you feel that I can help with the contact with Eagle Pass or the reservation, just let me know.
Okay.
But I will say, if you do go over to the CPS court, I know a lot of the caseworkers over there have had to have contact with the reservations. So they may be able to have a contact person for you.
Okay, perfect, Judge. I'll get on that.
All right. They'll give you a reset form just in case. And I'm sorry, which Native group are you with?
Kickapoo Traditional Tribe of Texas.
Okay. All right. Do you need the number?
I'm getting,
Okay.
that's what I'm getting.
All right.
Right now, Judge.
Oh, counsel, if you want to call them now, they don't close till 5.
So she gave me a contact number.
Okay.
for Rehabilitation Center with the tribe. I told her I'm gonna get on those calls right now.
Okay. All right. All right. Is there anything else?
Not this time, Judge.
Okay. All right. Thank you.
Just thinking if I call right now, it's lunch hour.
Yeah.